Hello, I want to say welcome or welcome back. If you're new around here, I'm Nike and you're watching Nike TV. It's not that I want you here. Yeah. It's not the way you said to my eyes. First things first, I'm kind of using my TV as a backdrop. The best lighting is here, so I just decided to put a nice little screen up there and record from here. I don't know why, I've never thought of this before, but I just happened to be testing out the camera and I realized that the lighting was really good right here, so this is what you're getting today. But you guys are not here for that. You're here because of the title of this video, obviously, and because you like to see my face. But seriously, we're here to talk about the sordid history of the South Carolina death row. Between January 1985 and May 2011, there have been 43 people executed in the state of South Carolina. Two of the most famous include Larry Gene Bell and Donald Pee Wee Gaskins. I'm going to be honest with you all. I don't know how accurate that information is. I simply did a Google search and that's what Wikipedia brought up, but it surely does not include the tragic murder of 14-year-old George Stinney, who was executed in Alcolu, South Carolina back in 1944 for the murder of two little white girls. But more on him back in 2021. Brad Sigmund and Freddie Owens were all set to die in South Carolina's electric chair. Lethal injection has not been used since 2011 because the state could not get their hands on the drugs. Now, according to representatives of the Department of Corrections, lethal injection was cruel and unusual because the paralytic agent just disguised the suffering. So lawyers for the Department of Corrections stated that South Carolina was just flat out refusing to go back to a method of execution that was going to cause suffering. Due to the shortage of these drugs, South Carolina entered into an involuntary 10-year pause because the law stated that the inmates could choose whether to be shot or electrocuted, but there was no firing squad as of that time. And from what I know now, there still is not a active firing squad, so the inmates have no choice in the way that they die, and based on an old statute, they are to have a choice. Back when I was still with the department, I remember when news of the impending execution of both Brad Sigmund and Freddie Owens came to light. We were told that we would have to leave early, we could not stay on the grounds or on the premises, everything would be shut down, no one going in, no one going out, and that's just proper protocol for when an execution is being held. I mean, security measures. You don't know if family members are going to come, they're going to show up, they're going to try to protest or try to cause problems. I mean, it made sense why it was happening, but all of this just seemed like theory. It never was put into practice because in reality, South Carolina could not go ahead with executing anybody because the firing squad was not complete, and nobody's going to choose to be electrocuted if there is supposed to be a choice of lethal injection, which is supposedly more humane, or a firing squad. And everybody, I'm sure, is familiar with what the electric chair is. But if you don't know what a firing squad is when the inmate is placed in a central location and several people are shooting at them. Just what it sounds like. It's a firing squad. But only one person is given actual bullets, the rest are given blanks, but nobody knows who that person is because the idea is to not have it on the conscience of the person who actually shot them. So if everybody is firing, you don't know whose bullet hit what, you don't know which one is the live round, which one was the blank. So that's the idea behind a firing squad. And as you can imagine, these guys had labored on death row for all of these years. They were not prepared to die. I mean, I'm sure that if I, knock on wood, was ever sentenced to death row, it probably would be on my mind every single day that at any time my card could be pulled and they're going to execute me. But because these guys were lulled into a false sense of security, they just thought that it wouldn't happen because it hadn't happened in the past decade. You know, the last person that they saw executed was in 2011, and here it is 2021, and they're still hanging on. So they just never thought that it was going to happen to them. So once this started being talked about again, in essence, that it didn't matter whether or not that South Carolina couldn't get their hands on the lethal injection drugs. We still had Old Sparky. We still had the electric chair. So that was a way for them to die. Somebody came in at the 11th hour and said, no, because there are supposed to be 3 ways of execution in South Carolina. And once again, that is firing squad, electric chair, or lethal injection. these guys' constitutional rights were being violated because they were not given a choice, due to the fact that South Carolina could not give them lethal injection, and it could not bring the firing squad, which I'm not sure which one they would have chosen, but it was just a means of a stay of execution. It was really a legal tactic, and I'm sorry about what you guys hear outside. My neighbors are outside working on their car. Now, there is a statute that states that the inmates have to die if they're up for execution. They have to die based on whatever methods are available at the time. But lawyers for the men were able to block that, stating that electrocution was a less humane way to die, which in my personal opinion, the victims don't get to choose their method of execution. I mean, whatever you choose to do with them, that's what's going to happen. But I digress. The point of the matter is, these guys can go out there and do whatever they want to do, but they have to have some say-so and some right in the way that they die, which I will never understand for the life of me, regardless of how long I study criminal justice, regardless of how long I take deep dives into true crime. That just blows my mind. Whatever the case, a lawsuit was filed shortly after Governor Henry McMaster signed into law a bill that states that the executions could resume. Attorneys for Governor McMaster and the Department of Corrections stated that inmates do not have the right to choose the way that they're going to die. In fact, they are only able to choose between whatever methods are available at that time. And at the time, there was only electrocution. So that was what was supposed to happen. But the lawsuit ended up blocking those efforts, and both men remain alive to this day. And it is important to note that both Sigmund and Owens have run out of traditional appeals. The only thing keeping them alive is the sorting of this law. South Carolina is one of 8 states to still use an electric chair, and only one of 4 to allow a firing squad. South Carolina's last execution, as I stated before, was carried out in 2011. Their batch of lethal injection drugs expired 2 years later, which says to me, and a lot of people researching this type of topic, that it is senseless to hold these people on death row for years upon years upon years. I understand that they have to go through the appeals process. I understand that some people could be innocent. So you do want to allow for that type of thing to happen. But for the people who have run out of appeals, why are we allowing such drugs to expire when no one knows if you're going to be able to get your hands on them in the future? And South Carolina has learned that lesson in the most horrible way. Like, they can't get their hands on it. So now they just have inmates sitting there because, again, nobody's going to choose, nobody in their right mind anyway, is going to choose to be electrocuted or shot when they could just simply go to sleep and never wake up again. Brad Sigmund has been on death row since 2002 when he was tried and convicted for killing his ex-girlfriend's parents with a baseball bat in their Greenville County home. Owens has been on death row since 1999 when he was tried and convicted for the killing of a gas station employee, Irene Graves, also in Greenville County. It has got to be the most ignorant move since I don't know when. He was allowed to legally change his name in 2015 to, and let me read this so that I am totally accurate, Khalil Divine Black Son Allah. So to sum it all up, South Carolina will not be executing anyone until that firing squad is formed. Now, when that comes about, I am sure that all of this hoopla and legal ramifications will be out of the way, and they won't have a choice anymore other than the electrocution and the firing squad, which I couldn't imagine dying by either one. But at that point in time, I'm sure that executions will go ahead as scheduled. But this is where South Carolina sits with its state of executions, since it has been allowed to resume. Now, you remember in the beginning of this video, I spoke about 14-year-old George Stinney Jr., who was executed back in 1944 in Alcolu, which is in Clarendon County, South Carolina, for the killing of 2 little white girls. Let's get a little into that. Before I take a deep dive into this case myself, upon doing my research, I stumbled upon a video of a man who was recounting the details as told by his father from when he was 13 years old and this case occurred. I want you guys to hear a little bit of that so that you can hear the general idea surrounding George Stinney and his execution at the time. Understand that this man was 13 years old at the time of the execution. He is now an old man himself, but he still is set in his ways about what happened and what occurred. And he really believes that George Stinney got what he deserved, although it has been proven that this man or this young boy did not commit this crime all these years earlier. But I'm going to stop rambling and let you guys hear a brief portion of this man's interview, and then I'll...
What do you remember about this case?
I remember
Dad coming in from work and telling us that these two girls were missing this particular afternoon, and he, with a lot of the other people in the community, of course, went out to look for them. And I'm going to tell you what he told me and what I remember about it. They told the people in the search that if they were found, they would blow the whistle at the mill so everybody would know that they'd been found and to come in. And at 1 minute to 7 the next morning, the mill whistle went off. A long, long blast, indicating that the girls had been found. Dad told us, and he had no reason to lie to us, that this black lady had told Mr. Alderman, Ben Alderman, that her grandson, who was staying with her, had told her what he did. And so it was our understanding that Mr. Alderman, along with the other authorities, went to his house, picked him up, and they had him in the back seat of the car, according to my dad, covered him with the coat where nobody would know he was even in the car. He carried them back to the location where the little girls were found and showed them where they were. The bicycle was in the ditch with them. Basically, that's all I know. That's all I was told. There was no real. There was a lot of sadness in the community, but I saw no uprising or running people out of town, or that may have been the case, but I didn't know it. And I was 13 years old, and I feel like I would have known it, seen it, or felt it if it was there, but it really wasn't.
When you learned that a kid was arrested for the murders, like, what was your reaction?
I can only tell you I was saddened. I was saddened more for the little girls than I was for the kid that was guilty, because if he did it, he got what he deserved.
Now I want you all to take note of the fact that Mr. Ridgeway said something really critical in his interview. He said if he did it, then he got what he deserved.
If he did it, he got what he deserved.
So if means that there is certainly a degree of uncertainty whether George Stinney did what he is accused of or not. And that makes it all the more tragic. And you might be wondering what it is that he had supposedly done. So let me tell you a little bit about the story of George Stinney Jr. Back in 1944 in Alcolu, South Carolina, he and his sister were apparently standing in their front yard when Betty Binnicker and Mary Thames came along and asked them where they could find the flower maypops. So as the story goes, the girls got directions to the maypops from George, and he apparently walked off with them to show them where the maypops were. Now, this is the account of the people who took George to trial, because his sister has a total different account from what they are saying. Because according to her, they were not able to leave the property without their parents being home.
Well, I put it like this. My mother and father was strict. We could not go anywhere out the yard unless they gave us permission.
Okay.
Only thing we did was went to school and to church and back home.
And neither of them were home at the time, so George would not have walked off with these girls. But to continue, he supposedly took them to find the maypops, and the next thing you know, the girls were reported as missing, and he was said to be the last person to be in their presence. A search party was formed with the inclusion of George's father, and the girls were subsequently located in a ditch, and they had been said to have been beaten with a railroad spike. And here is a railroad spike. Now, according to the court of public opinion, because nobody was there except these girls and whoever was their murderer, George apparently wanted to have sex with Betty Binnicker because she was the oldest of the two, but she refused. So he killed the younger girl so that there would be no witnesses. He then sexually assaulted Betty Binnicker and then murdered her. As Mr. Ridgeway stated, their bodies were then located in a ditch after the search party did locate their bodies, and that led them right to the front door of George Stinney and his family. His parents, again, were not home when authorities came to look for him. They led him away, they put him in a car, and they took him down to the courthouse where they subjected this boy to intense scrutiny and interrogation. So you think about it. You as a 14-year-old child, if you have these police officers driving into your head that you did something that you know that you didn't do, and to make matters worse, this was back in the segregated South, where blacks essentially had no rights. They told him that he killed these girls, and he really had no choice but to agree. They wanted to close this case because of the families of these girls. They felt like they had gone through enough, and it made them feel good to feel like they had the suspect in custody and that they could do something about a black boy killing 2 little white girls. If you know anything about the racially segregated South, then you know that this was not going to blow over well. Hell, in today's time, it's not going to blow over well. So imagine back then when we did not have the legal wherewithal and the know-how to really defend ourselves. And to make matters worse, once again, his parents were not allowed to be there with him while he was interrogated. He signed this statement, which I know he did not write, because this boy had no idea what happened. The only thing that he knew is that these little girls came upon his home, asked where they could find maypops, and he gave them directions. That was the extent of his involvement. But that is not what the authorities said. As a result, the family was all but run out of town. His father worked at the local sawmill. He had to leave his job there if he wasn't fired. They had to leave in the dead of night because they were worried about a mob coming to get them because of what their brother and son was accused of doing. It was a really scary time for them, although nobody had a shred of evidence that this boy did anything other than the fact that he saw these girls. So this was March 22nd, 1944. The bodies were subsequently discovered on March 23rd, 1944, in what was called the African American side of town. So apparently Alcolu was split. African Americans lived on one side and the white citizens lived on a total different side. And these girls had wandered to the African American side and ended up dead. George's sister Amy was with him at the time, and she breaks down the fact that her brother was with her the entire time. The only thing he did, as I've stated many times before, is give these girls the directions to where they could find the maypops. That's it. Reports differ as to what the murder weapon was, but the general consensus is a railroad spike. And both girls suffered blunt force trauma to the face and the head. Both girls had their skulls punctured, and though both their hymens remain intact, Betty June Benneker did have some bruising to the genitalia. Both George and his brother John were arrested at the time, but only George was held in custody. John was subsequently released, and he was not allowed to see his parents until after the trial and conviction. According to Deputy H.S. Newman, George told him that he knew where he could find the murder weapon as well as the bicycle. But understand that George's father did aid in that search, and people talk. I'm sure when he got home, just like Mr. Ridgeway's father, he discussed the facts of the case. He did not know that his son was under scrutiny and under suspicion, but I'm sure he came home and just shared, just as dinner table conversation probably, where everything was located because he was out there. And George probably retained that information and told the sheriff or the deputy in passing conversation, oh yeah, I know where they found this, that, and the third. He was 14. He did not know to keep his mouth shut. He had never had any legal issues before. One of George's teachers testified that he was violent in school. He got into a lot of fights and that he had even scratched a little girl with a knife. But his sister Amy quickly put that to rest, stating that that account was just something. It's not true. It was not her brother. That they were trying to fuel a fire that was already raging. Another local white woman claimed that George had threatened to kill her and her friend the day before the murder. And here's a little of that interview with her.
We lived right back close to Green Hill Baptist Church. We lived back there right close to it. And Ruth's sister, Violet Freeman, went home with me from school. And after we got through eating, we went down to the church to get some water, because we had an open well, and Mama didn't like for us to drink that water. So we went down to the church to get some water to take back to the house. And we got to playing down there under an oak tree, and this black boy came down there pushing a tricycle, the foot on the back and holding the handles and pushing with the other foot. And he came up to us and he wanted to know what were we doing down there. I said, we came to get some water and we just got to playing down here. He said, well, if you don't get away from here and if you come back, I will kill you. That was the evening before the little Benneker girl and Tim's girl went missing.
Editing Nike here. Now, I don't know about you, but to me that sounds like, one, she's just trying to be relevant. Two, notice she never said his name. She said the little black boy. So that could have been anybody, because remember, they were on the African American side. But she claims to be talking about George Stinney. The title of the interview is literally George Stinney Threatened to Kill Me. And another thing, knowing what we know about the segregated South, it just sounds weird to me that they would answer to a little black boy. You know, it just seems to me that they would have felt like they were above that. But moving on. Although the Sixth Amendment now guarantees the right to counsel, this was not widely observed back then. It actually did not come into play until 1963 during the trial of Gideon versus Wainwright. The entire proceeding against George Stinney took 1 day, just one, including the jury selection process. George was afforded a court-appointed attorney, but this man really was not an attorney. He was a tax commissioner who was campaigning at the same time. So he did not challenge anything. He did not ask any questions. There were no African Americans in the courtroom. This man called no witnesses. He really just botched this trial. I'm sure he was getting paid on the back end. He was taking some sort of kickback to get this done, and it was an election year. So everything was stacked against George. He did not challenge the 3 police officers who stated that George confessed to this, nor did he bring up the fact that there were differing versions of this supposed confession. And to date, there is no written record of George's confession other than the statement of HS. More than 1,000 white people crowded this courtroom. No blacks were allowed to attend, with the inclusion of George's parents or his family. So you have to understand that these people had something to lose. If there was a crowd of 1,000 people, it was an election year, what do you think that they were going to do? George's family, his churches, including the NAACP, appealed to the governor to give this little boy clemency, given his age at the time. That was denied. This was at the urging of others who really wanted the trial to proceed, because once again, this was the segregated South, and a little black boy was convicted or on trial for killing 2 white girls. So white people were in an uproar, and they were stating that this was not going to go unnoticed. So you have to understand, if he did not proceed with this trial, vigilante justice was going to come into play. So either way you look at it, it was not going to be a nice outcome. George's parents were only allowed to see him 1 time after the trial, when he was being held at the Columbia Penitentiary, which used to be called CCI, but is no longer in existence. There are actually apartments over there right now, but they could only see him that 1 time under the threat of lynching, and they were not about to take that chance. The jury deliberated for less than 10 minutes, and they came back and found George guilty. He was then sentenced to death by electrocution. Death by electrocution in the South Carolina electric chair, which was to be carried out soon after. There is no transcript of that case, and no appeal was filed by Stinney's counsel, which is not surprising. But I will say this. I used to have a habit when I worked at the Department of Corrections of going through old case records. I used to look at everything. I was intrigued by all of the old cases, and try as I might, I could not find anything related to George Stinney. You could see that he used to be an inmate, but you cannot see any information, not even the slightest thing, like where he was held. And I think that might have been his father, because the timing just did not add up, or it might have been a descendant of his. Either way, there was no information about George Stinney, which I always found surprising. So I called down to Inmate Records one day, and I asked them if it was okay for me to go down there and to look through the files. And the lady told me there's not much to see regarding George Stinney, but you're welcome to it. And I didn't even go, because I knew then that it would be a waste of time. South Carolina all but swept this under the rug. And the fact that there was no transcript, there was no appeals filed, means there's really no information. George was then executed on June 16th, 1944. So remember, I told you this occurred on March 22nd, 1944. So you have a span of less than 3 months where they carried out this execution, and he had to sit on a Bible because he was just too small for the electric chair. Only his father was allowed to approach the electric chair to say his final goodbyes to his son on behalf of him and the family. They did ask George if he had any final words, and he only shook his head. No, he had nothing to say, and rightfully so. The executioner pulled a strap over George's mouth, which caused him to break into tears. They then put on everything else, including the head strap, which did not fit him, and he was executed. Given the fact that the mask was too big, it slipped off of his face, and the last image that they had of this poor boy was him breaking into tears as he was electrocuted in his chair for a crime he did not commit and knew he did not commit. But that's not the end of it. In 2004, George's case was reopened when George Frierson, a local historian, started looking into the case after he heard a newspaper article about it, and thank God for George. His work gained the attention of some prominent South Carolina attorneys, which prompted them to look even further into this case and to find documentation which later exonerated George Stinney. So although he had already been tried and executed and buried at this point, they still went back and they cleared his name no matter how many years later. It's better late than never, because this boy's history was forever soiled by the fact that he was accused of committing a crime that he did not commit, because the local authorities were too lazy to look into what actually happened to these girls, and they used him as a scapegoat even at the age of 14 years old. And his father, his mother, nobody was able to do anything at the risk of their own lives or the rest of their children's lives. December 16, 2014, Circuit Court Judge Carmen Mullen finally vacated George Stinney's conviction after all those years, and that trial was put to rest. Although Betty Beneker and Mary Thames' family expressed disappointment at the reversal of the conviction, what was done was done. I mean, what people don't realize is that nobody won in this case. Nobody. Not at the time when George was executed, and not now that he was exonerated. He is still dead. Exoneration does not mean he comes back from the dead and gets to live the rest of his life up until this time. It just means that the truth finally came out, and they were not able to live with that. They did not like the fact that the court said he did not do it because other evidence was found. But that's besides the point, because it happened, and now he has his history erased, and he does not have to be known as the little boy who murdered 2 little white girls back in 1944. Judge Mullen, who was the only one to have some sense in this case, ruled that the confession was likely coerced, and it was. Because you have to think, once again, this was 1944. How educated could this boy have been? First of all, to write the statement that they said that he wrote. But besides that, he was 14. He did not understand legalese. He did not understand what they were telling him to do or what he was accused of. The only thing he knew is that they had something on him because he was the last one, along with his sister, to see this little girl. And I'm sure at some point, you know, his brotherly instinct kicked in when they did arrest John as well. And he probably wanted to protect them. You know, let my brother go. I'll say whatever. I'm just speculating at this point. But a lot of things come into play when I think about how this case was handled. Jr. So a lot of Georges in this case has come into scrutiny as a suspect for the actual murderer of these 2 little girls, which makes more sense, because what little boy do you know that's going to think about rape and murder of 2 little? It doesn't make sense then, and it doesn't make sense now. I mean, I could see him possibly beating them to death, but given the circumstances of this case, that does not fit a 14-year-old. Not back in those times. And Wayne Burke, George Burke's son, supposedly stated that he had been told his father had picked up the girls prior to them going missing and offered to help them pick flowers. He then recanted his statement, but it had already been put out there. Books have been written about this case, movies have been made, but one thing sticks out in the hearts and the mind of the people. This was a tragedy all the way around, which further lends credence to the fact that South Carolina has a sordid history where the death penalty is concerned. I would not trust my dog to South Carolina to give him the death penalty. I mean, it's probably a blessing in disguise that it's not happening at this point, because it seems like nobody is doing their due diligence where these things are concerned. Now, do I believe in the death penalty? Am I a proponent for it? I'm not going to get into that. Do I believe that it is warranted sometime? Absolutely. But do I believe that it should be a means to an end? I'm not going to get into that. You guys have your own opinions and your feelings about it, and I don't want to get into a political debate regarding this. But one thing remains true. Executing someone at the age of 14 years old after 10 minutes of deliberation is wrong, it was wrong, and it will forever be wrong. The end. But that was the end of this episode. I hope you guys enjoyed it. Let me know your comments your feelings about how you felt about this. Let me know if you want to hear more historic cases as far as South Carolina is concerned. And I will see you guys in the next one.